We will post a link and submit the recording of the webinar for you to share with colleagues at the conclusion of the webinar. In addition, we will be sending out a slide deck that we are going over today to all participants. So with that, I'll advance the slide to the next section here. And unfortunately, due to the high volume and demand, the slide function is moving rather slowly, which is unfortunate. Bear with me.
Jason, this is Sean. Can you hear me?
Yes, I can hear you just fine, Sean.
Great.
Welcome.
Thanks.
Okay, so today's presenters will include Sean Monson. Sean will be covering FMLA and the amendments made to FMLA. Susan Motschiedler will be covering sick leave under the Response Act. Ross Keogh will be covering the tax credits under the Response Act. Christina Jepson will be covering issues related to the WARN Act. And as mentioned previously, Mark Wagner will be facilitating any questions that you may have throughout the webinar session. Sean, I'm now going to turn the time over to you, and hopefully our slide will advance more quickly as we move forward here. I'll let you start with our typical legal disclaimer, Sean.
Great. So thanks everyone for joining our webinar today. This has obviously been very fast and furious with lots of twists and turns on this legislation. From the time that the legislation was passed last Saturday evening, I guess 2 Saturday evenings ago, and then when it evolved to when the Senate passed on Wednesday, there were substantial changes to it. And then this last Friday, just a couple days ago, we got some guidance from the Treasury Department regarding how some of the provisions, particularly the tax credit and reimbursement provisions, are going to work. And Ross Keogh is going to speak a little bit more about that. So if you go to the next slide, Jason. So the first thing I'm going to talk about is the amendments that the statute made to the Family Medical Leave Act. As you are all probably familiar with, the Family Medical Leave Act is a statute that provides employees with leave rights for a serious health condition of their own, or a serious health condition of a family member, or for the birth or adoption of a child. And it applies to employers who have 50 or more employees. In order to be eligible, an employee claiming leave for those reasons has to have worked for the employer for a year previously and worked for 1,250 hours during that year. So that's kind of what we would call the traditional or the regular FMLA. What this statute did is it revised the FMLA beginning on April 2nd, 2020, and ending on December 31st, 2018. It amended it to provide for leave with regard to COVID-19 illnesses. And this is one of the significant areas that I think is a little bit confusing for most people who are somewhat familiar with the statute and were reading the newspaper reports. The statute changed from the Saturday version that the House passed to the Wednesday version that the Senate passed with regard to the triggering events under the FMLA amendments. So what the statute did is it said, Congress said we are now going to create a new right to FMLA leave. And that new right to FMLA leave is triggered when an employee has to care for his or her child because that child's school has been closed or because that child's child care provider no longer provide that service. So that it creates a new leave right under that circumstance and that circumstance only. When the bill was originally passed by Congress, there were a number of different triggers, but that's the trigger. So if you look at this chart we provided here, it talks about, under the regular FMLA leave portion, again, it applies to employers who have 50 or more employees within a 75-mile radius. The employee has to have worked 1,250 hours in the previous 12 months, and then it has those triggering events I talked about. With this statute, there is, again, some significant changes in terms of what the eligibility requirements are and what the triggering event is, and also what the leave entails. So the triggering event, again, is the employee is unable to work because they have to care for a child whose school has been closed or whose preschool provider can no longer provide care. It also changes what employees are eligible. In order to be eligible for this new COVID-19 leave, the employee only has to have worked for 30 days for the employer before they're entitled to leave. And the other significant change in terms of the coverage is under the regular FMLA, it only applies to employers who have 50 or more employees. Under this amendment to the FMLA, and again, this amendment only relates to COVID-19 relief, COVID-19 leave. But the employers that are governed by the statute are employers with 50 or fewer employees. 500 or fewer employees. So it applies to, if you have one employee, statute is going to apply to you. Now, there are going to be regulations that come out on April 2nd where the Department of Labor is going to talk about how employers with 50 or fewer employees might be exempt or obtain an exemption from the amendments. But we don't know what those look like yet. Essentially, the limited guidance we've seen so far, it's going to be a situation where the employer is going to have to demonstrate that complying with these rights is going to create a significant business hardship for that employer. So again, there's the expansion of what employers are covered. Employers with 500 or fewer employees. The Act provides for much greater access to employees. They only have to work 30 days for the employer to be entitled to the leave rights. And then it has a single triggering event, which is the employee has to provide has to care for a child who has had their school closed because of COVID-19, or the child care provider that they normally use is no longer available. All right, Jason, we go to the next slide. So the benefits, and this is where the biggest change and where most employers' concerns come about. Under the regular FMLA, the leave benefits are 12 weeks of unpaid leave. Under this new COVID-19 leave, the employee gets 10 days of unpaid leave. After those 10 days of unpaid leave, from day 11 to the end of 12 weeks, the employee gets paid 2/3 of their regular rate of pay. That is calculated on the number of hours that the employee would normally be scheduled to work. If they have an irregular schedule, then it's a 6-month average. The paid leave benefit is capped, and the cap is for $200 a day, or $10,000 the aggregate per employee. Now, the one other significant distinction between what we would call regular FMLA and this COVID-19 FMLA leave provision is that under the regular FMLA, when an employee takes leave, an employer can force the employee to use accrued but unused paid time off or sick leave during that period of time. Under this statute, when an employee is taking COVID-19 leave, it is up to the employee whether they take an accrued but unused PTO benefit. The employer cannot force them to take that PTO. So that's another significant difference between the regular FMLA and this revision for COVID-19 leave. Now, the reinstatement rights are generally the same as you all are aware. The Family Medical Leave Act requires employers to reinstate employees upon their return from leave. The reinstatement rights are generally the same, except for there's a slight difference under the COVID-19 reinstatement rights when the employer has fewer than 50 employees. So one of the things that we're getting a lot of questions on is what happens if we are, after April 2nd and our business continues to go down and we have to have a layoff or we have to have a shutdown. Under the FMLA, an employee does not get greater rights than they otherwise would have had. So irrespective of whether that employee was taking leave, if there was going to be a company shutdown or a company layoff, it happens even while the employee is on leave, they're no longer entitled to those rights. And so if there is a company-wide layoff or if there is a company-wide shutdown, even while the employee is on leave, they're not going to be entitled to these leave rights. The key is going to be is you're going to have to show that the reason why the employee has been let go, or the reason is not because that the employee took the leave rights, but because of reasons that were completely unrelated to the leave. And that would be, obviously in the case if the company closes its doors, either because of a mandated government order or because business has tanked, or if there's a significant layoff, and that would be a reason that the employee is no longer working and the employee is being terminated, as opposed to that employee having exercised his or her leave rights. Another question that we're getting a lot of questions about is, how does the 500 employee limit work? Can you aggregate locations? If you have related businesses, can those be aggregated? There really isn't any particular guidance that's been issued with regard to this amendment. Under the FMLA, when an employer is, when the issue of whether the employer employs 50 or more employees is present, there has been case law that has been developed that essentially talks about a integrated employer. And what that means is that if there are related businesses that have some common labor management or labor supervision, that under certain circumstances, those separate employers or the subsidiary employers can be aggregated for purposes of calculating whether that employer has 50 or more employees. Absent any further direction from the Department of Labor, I think that case law and that concept would likely apply to the issue of whether an employer has 500 or more employees. And so the factors that courts look at with regard to the interrelated employer doctrine are interrelation of operations like common offices, common record keeping, shared bank accounts and equipment, common management, common board of directors, centralized control of labor relations and personnel, and common ownership and financial control. Not all of those factors have to be present, and it's a kind of a totality of the circumstances analysis. Most courts say that the third element, which is the centralized control of labor relations, is the most important element in determining whether an employer has 50 or more employees. The last thing that I think is important that a lot of employers have been asking us about, and that Ross is going to talk a bit more about, is the tax credits. And Ross that's what we've initially understood based on the language of the statute, changed a little bit based on the guidance that the Treasury issued, because the Treasury gave some guidance that indicates that the reimbursements for employers who have to pay this COVID-19 leave are going to be quicker and are going to be coming a lot faster than we originally thought. The last thing that I wanted to mention in those the guidance that came out on Friday from the Department of Treasury, even though the Department of Treasury is not the Department of Labor, the guidance says that the Department of Labor is going to not initially enforce this statute. They're going to have a grace period for employers who engage in good faith efforts to try to comply. And during that, if an employer has engaged in good faith efforts to employ, rather than bringing in enforcement action and penalizing the employer, the Department of Labor is going to work with that employer for 30 days to try to bring them into compliance. So those are kind of that's kind of the summary of the statute, some of the issues that we have been dealing with as we've been talking with employers. If any of you have questions about that, about what we talked about, or about the amendments, please send them on the chat line, and then we can get those answered during the question and answer period. Thanks.
Thank you, Sean.
And this is Susan Motschiedler now. Can you mute your line, Sean, and then forward to the next slide, please, Jason?
Yep, Susan, I'm having some difficulty again with the slide freezing up, so I'll get there. Please proceed.
No worries, I'll just start. The Response Act also provides for paid sick leave, and it's a little bit easier than the FMLA leave because it doesn't alter an existing statutory scheme. It creates a new entitlement whole cloth for employees who are eligible. Like the FMLA, however, the COVID-19 FMLA leave, it applies to employers with 500 or fewer employees. Like Sean mentioned, it is possible that employees can take advantage of different tests to stack their employees together as an integrated employer. I would probably caution that before you do that, you might want to consider ramifications down the road for integrating all of your businesses and subs and that sort of thing for future purposes under other employment laws. The sick leave entitlement, just like FMLA, begins April 2nd, 2020 and ends December 31st of this year. So it's not going to create a permanent sick leave at the federal level. The provisions here also provide that the Department of Labor has the authority to promulgate regulations. We've seen a notice on the DOL website that they plan to do that in April. They are not quite as swift as the Treasury Department, but will probably echo some of Treasury's points that Ross is going to talk about. It also provides that the Department of Labor can exempt small businesses with fewer than 50 employees if sick leave benefits would jeopardize the viability of the business as a going concern. And it's unclear at this point how easy it's going to be to make that showing, given that there are tax credits that go with this. And for businesses that shut down completely and have no income, Ross is going to address the way the credit works may not benefit those employees or employers. The Department of Labor can also exclude healthcare providers and emergency responders from the definition of employers under the Act. And if the DOL doesn't do that, then the Response Act permits those employers to opt out if there are no regulations excluding them in the future. We anticipate that the DOL is going to provide a lot more flesh to put on the bones of the Act to determine how this is going to be rolled out. And as Sean said, the first 30 days is not going to be an enforcement period. It's going to be primarily an advice period. And can I get the next slide? So who all is eligible? Employees who are full or part-time are eligible. It does not matter how long the employee has worked for the employer. So if you hired someone a week ago, they would be eligible for this benefit. It applies to any employee who is unable to work, including telework, because they either themselves are in quarantine or are caring for someone in quarantine. So that reflects the same statutory scheme that the COVID-19 FMLA section does. So if they are in a federal, state, or local quarantine order related to COVID-19, they're eligible for sick leave. If they have been advised by a healthcare provider to self-quarantine due to COVID-19 concerns, or if they themselves are experiencing symptoms of COVID-19. And there's some open question of how broadly the local quarantine, that's the federal, state, or local quarantine, will be interpreted, and whether or not that will include certain closures or health closures, sort of thing. The other category of employee that's eligible is someone who's caring for someone who is subject to such a quarantine, or someone who is caring for someone who has been advised to self-quarantine, or if they're caring for their own school children whose school or care provider is unavailable due to COVID-19 concerns. And then there's also this catch-all provision that if they are experiencing any other substantially similar conditions specified by Health and Human Services. So it does provide some wiggle room that perhaps other illnesses are going to be added to this that aren't necessarily COVID-19 directly caused by the coronavirus, but perhaps a related illness. Can I get the next slide? So what are these employees entitled to? And it varies by full or part-time. Full-time employees are entitled to up to 80 hours of pay. Part-time employees are entitled to the average number of hours the employee works over a 2-week period. If they work variable schedules, or if they haven't been, well, if they work variable schedules, it'll be based on an average of the prior 6 months. And then if they haven't worked for the employer for 6 months, it will be based upon the employee's reasonable expectation upon hire. And so you would probably look to any sort of offer letter or advertisements indicating what the hours would be for that position. Next slide, please. The amount of sick leave also varies according to the purpose of the leave. So individuals who are themselves sick or in quarantine get the most. They get 100% of their regular rate of pay that they would have earned working normal hours up to 80 hours. It's also, like FMLA leave, capped at $511 a day, or $5,100 in the aggregate. Employees who are caring for a qualified person, so someone else who's under quarantine or a child whose school is unavailable, they get about 2/3 of the regular rate of pay. It's capped at $200 or $2,000 in the aggregate. I think it's worth noting, and we've had a number of questions, does this apply to part-time employees who otherwise don't get benefits? And yes, it does. There's no other qualification besides your part-time, and you hit one of the care provisions or quarantine provisions. And then if this applies to you, there is under multi-employer bargaining agreements, the bargaining agreement the multi-employer may, consistent with such an agreement, fulfill those sick pay obligations by making their pro rata share based on the number of hours that the employee works for the individual employer. And then finally, there's a bucket of miscellaneous provisions. Some of them are notice provisions that, next slide, if you could, thanks. That the employers need to post a notice. I think the DOL, they have done that. There is a notice available on their website. The employees seeking sick time under the Response Act don't need to find a replacement for their missed hours. And that's even if they're not sick, they've just been advised to quarantine and they're otherwise able. They don't have to find a replacement. The employer, importantly, cannot require, just like under COVID-19 FMLA, they can't require the employees to use any other paid leave that's available to them. So their federally mandated sick pay under the Response Act comes first, and then they would be allowed to take other sick leave according to policy. The sick leave does not roll over. This act does end December 31st. So if employees don't use it by then, they don't get it. The Response Act also provides for penalties under the FLSA. And so generally, FLSA penalties include $1,000 per violation, For willful violations, there can be a $10,000 fine and criminal prosecution. And I suspect that the DOL will probably flesh that out a little bit further and provide some advice as to what the exact penalties will be. So thank you. That concludes my section.
Ross, we'll turn the time over to you. Thank you, Susan. Ross, you might be muted.
Thank you. Thank you, Sean or Jason, for that quick review of the act. And then maybe I'll just provide a quick review before we jump in. So, right, last week, Tuesday, Congress, this bill was passed, signed into law. It mandates by the Thursday of next week that all employers with less than 500 people provide two functionally new benefits, some sort of paid sick leave component and some sort of FMLA leave component for those that need to take leave related to COVID-19. This was a deliberate, this act was a deliberate intent to use employers as a conduit to get money into the economy to help offset the costs of those people not being able to participate in the labor force. And that's, I think once you step back and look at the act in that way, a lot of it starts to make more sense. And so I'm going to talk about the other side of this, right? How Treasury is going to give employers money to offset the cost, most of the cost of the benefits that Sean and Susan talked about that they now have to provide to all employers. So there are 4 separate tax credits. We can think about them really as 2. There's a paid sick leave tax credit. There's a tax credit for any paid FMLA leave that is offered. And then there are also corresponding tax credits that are available for self-employed individuals. Think about our gig economy workers that might have to take leave related to COVID-19. So the first, the paid sick leave, it has those same caps that Susan talked about, $200 for care of others or $511 if you are quarantining. That is capped again at 10 days per employee. We also have a paid sick leave for self-employed individuals. This is going to be a function of that individual's average daily self-employment income. So we take a base amount for a taxable year that we don't know yet, either probably 2019 or 2020, and we divide that by 260 to give us the credit limitation for those individuals. Jason, next slide, please. On the family medical leave side, the credits are again limited to 200 days, $200 per day, or $10,000 maximum per employee. And we see another credit here for self-employed individuals that need to take family medical leave. And we're gonna have a further limitation of 67% of that average daily self-employment income, that ADSEI. Next slide, please. So here's some other details on the restrictions or the application of the credit. First of all, public employers are the one class of employers that aren't eligible for either of the credits, either the sick leave or the FMLSA leave. All payments made by the credit are exempt from your Social Security and Medicare withholdings. In addition, if you're a self-employed individual, there's going to be another limitation as a function at 67% of your ADSEI for the sick leave credit. And if you are a self-employed individual that wants to take advantage of the sick leave credit, you're going to have to be able to demonstrate that it wasn't just you were able to do your current trader business, but you were unable to perform services in any other trader business. I think we'll see some guidance on Treasury on that point in particular that might relax that a little bit. Fine, Jason, if we could just go back one slide. The other thing to note that if an employer has a qualified health plan and they're going to incorporate some of these paid elements into that plan, that they'll be able to apply the credits to the marginal cost of implementing the Response Act in that plan. This will be another area we'll expect to see significant guidance from Treasury on how that implementation will work. And then finally, I think it's fair to say that Treasury is going to take wide latitude in interpreting this rule. And I'm going to talk a little bit about the action Treasury took Friday on the next slide. So how do employers get the credit and how's the credit going to work? Treasury issued a news release on Friday that outlined what forthcoming guidance is going to look like. They committed to providing that guidance this week, right? Because the following Thursday, we have to implement this act. That guidance indicated that an employer will be able to take the credit against its liability in the following categories. This is a payroll tax credit. They'll be able to offset the employer's side of Social Security and Medicare and the employee's side of Social Security and Medicare. And I think most surprisingly is the employee's federal tax withholdings. They'll be able to offset that obligation at the employer level. There will also be a process. There's going to be a form that's issued where employers can ask for accelerated payments based on an anticipated liability. And that we will have that form Treasury committed by the end of this week. Again, the credits are refundable. So to the extent the employer's tax liability isn't present, they can get a cash payment for covering these expenses and the offering of this leave. Next slide. I'm primarily a tax attorney, and so I get to work with numbers. And so I think it's helpful to put a few data points on what some of these numbers mean and where they came from. So when we think about the $500 per day credit, that is equivalent to the 2019 Social Security wage of $132,900. So if you're an employer, unless you are paying your employees more than that amount, you're generally going to be made whole by the availability of that credit. We can also think about the $200 per day credit as being a wage base of $52,500, which again, as Susan pointed out, is a 2/3 credit. So there's a little bit more wage, but the vast majority of the American workforce is going to be under these thresholds, and the employers are going to get almost a complete coverage of their costs. When we think about applying the credit at the individual level, recall that Social Security and Medicare have an equivalent amount of tax on the employment level of 15.3%. And if you add in the federal withholding amount, which can be 10 to 40%, about 1/3 on average of an employer's obligation on wages is going to be subject to refund by virtue of this credit. So I'm generally advising employers that if you have at least 2/3 of your workforce still employed, you're going to be able to get the benefit of these credits without having to seek the accelerated payment. Remember that this is a payroll tax credit, and so employer will functionally just make a reduced withholding payment, whether you're on monthly or semi-weekly. And then when you file your Form 941, you will reconcile the sick leave and the FMLA leave that you paid out on that Form 941 based on the employees that qualified under the Response Act. Self-employed individuals are going to have to wait a little bit longer. They won't see this credit have any benefit until they file their 1040 in 2021, but they will be able, and they should, start to make reductions in their estimated withholdings to get some of the cash benefit right now. I think that's all I have, Jason.
Hey, Ross, thank you very much. I'll now turn the time over to Christina Jepson.
Thank you. I'm going to be talking primarily about the WARN Act and layoffs and terminations. So obviously, everyone is thinking about that possibility right now, whether you're going to have to terminate some or all of your employees or lay them off. I'm going to try to use those terms more precisely than maybe we have in the past. When I say terminate, I really mean you're severing that person from an employment relationship with your company. They'll no longer be on payroll. They'll no longer be on health care. If I refer to a layoff or a furlough, that concept is really keeping someone on payroll, but they're not coming into work. They're still on benefits. So, really the WARN Act was passed in the late 1980s to require companies to give 60-day notice to employees when there was going to be a pretty big layoff at a pretty big company. And that makes a lot of sense. Employees need to get notice so that they have time to figure out what they're going to do, get another job, maybe get some free training. So that's really what the WARN Act is about. And normally when we're advising clients about that, the client is planning some kind of layoff and they have time to figure that out. They have time to get a 60-day notice out. As you can imagine, in this very strange time in American history and world history. We don't have time usually to do 60 days notice. Everyone's dealing with very different circumstances. So, does the WARN Act apply? Are there exceptions? That's what I'm going to be talking about. For the most part, it applies to large employers, which I'll define, to large layoffs, and there are some exceptions. Now, when I say that it only applies to large employers, what I mean by that is it applies to 100 employers with 100 or more full-time employees. Those are employees who work less than 20 hours, or excuse me, work more than 20 hours in a week. So not what we normally think of as full-time. Or it could be an employer who has 100 or more employees, including part-time employees, if they work at least 4,000 hours per week in aggregate. So those are what kind of qualifies as a large employer. Now, don't forget that some states have their own WARN Act, or they have some sort of state act that applies to terminations and layoffs. So your state might have an act that applies even at a smaller numbers. For example, in California, the mini WARN Act in California applies with 75 employees. So even though at the federal level it's basically 100, it might be less in your state. So you've got to look at that. And how these employees are counted exactly can be tricky. If you have 10 employees, you can rest assured that this does not apply to you. If you're closer to that 100, and you're not sure, exactly how to count employees, you should check with counsel and figure out exactly how you should be doing that. Okay, next slide, please. Now, as I mentioned before, this only applies to large reductions in force. This isn't letting go one or two people. There's really two kinds that it applies to, either a plant closing or a mass layoff. And you can forward the slide, but don't let the term plant closing confuse you. Plant closing isn't like we think of, it's like some factory plant. It could be any kind of business. A plant closing is a permanent or a temporary shutdown of a company or part of a company that involves at least 50 employees experiencing an employment loss. And I'll talk about how that's defined in a minute. But a permanent or temporary shutdown could be a single employment site. It could be one operating unit. It could be one facility. So maybe your whole company is not closing down, but one assembly line that makes, one product is going to completely close down. And if that impacts 50 employees, that could potentially be a plant closing. So again, these concepts can be a little bit tricky. Now, a mass layoff, on the other hand, is a reduction in force. Doesn't have to be a plant closing, but there have to be at least 500 employees at a single job site who have an employment loss, or 50 to 499 employees have an employment loss if that is 1/3 of your workforce. Those are the two scenarios. If you're sure that less than 50 employees are going to experience an employment loss, and there's not a mass layoff, it's not going to apply. Next slide. Now, when we talk about employment loss, this is really important, I think, particularly in these times. An employment loss can be a termination, of course, but it can also be a layoff where you just send people home for a period of time if it becomes long enough. So an employment loss is a termination, unless it's a termination for cause. If someone is doing something bad and gets fired, they get fired for performance, that's different. You don't have to count that. If they voluntarily leave, if they retire, those don't count. A layoff counts if it turns into a 6-month layoff. So if it becomes 6 consecutive months, that is a qualifying employment loss. It's also a qualifying employment loss if you have a reduction of hours of 50% during each month for 6 months consecutive. So in every situation you're looking at, am I a large enough employer? Is this going to be a plant closing or a mass layoff? Are enough employees going to be affected that this counts under the WARN Act? Okay, next slide, please. Now, there's a couple other tricky parts to the WARN Act that I won't go into great detail, but the WARN Act basically looks at a 30-day rolling period to see if there's enough employees affected. But on the other hand, they don't want employers to kind of let people go in, little small layoffs and try to avoid it going under the WARN Act. So there's kind of a 90-day look back and a 90-day look forward period to figure out all the people that maybe have been laid off. So again, this is a really tricky area. Just keep in mind that if you have sort of had rolling layoffs or terminations, and it might be approaching 50 people that you have to think about the WARN Act and that it might. Next slide. So if the WARN Act is triggered, what it requires is that you give 60 days written advance notice to your employees that they're going to be let go. And those warnings have to go to a number of people. They have to go to a union representative if you have collective bargaining in your workplace. They have to go to the affected employees directly if there's not a union. It has to go to the state dislocated worker office, and that's really so the state can get involved in helping people find jobs. The local government has to be advised. Sometimes the federal government has to be advised. You can see how this is really geared towards more the normal world that we're used to working under. It might apply now still, but it's probably going to be unlikely in these days that people are going to have 60 days notice. So we're going to talk a little more about that if you want to advance the slide. Just to let you know, if there is a violation, it can be very pricey. Basically, if you don't give 60 days notice, you owe the employee for that 60 days of pay. You also owe them benefits for that 60-day or any period that you failed to give notice, and attorney's fees, which can also be very large. And then on the next slide, it just talks a little bit about how there can also be subject to civil penalties if there's a violation of WARN. Now, if you advance the slide, I want to talk a little bit about a COVID-19 shutdown. Now, if your company has been basically ordered by a local, state, or federal government to shut down because of COVID-19, for example, a lot of states right now, California, Nevada to some degree, New York, other states have said all non-essential businesses have to shut down. If that's the case, there's a very strong argument, obviously, that you had no choice, you had no opportunity to give 60 days notice. It's unlikely that the WARN Act applies in a situation like that, because it's really not the employer causing an employment loss, it's the government saying that you have to close down. And nonetheless, you want to give as much notice as you possibly can if you understand that this order is coming. If you get the order before your employees, you want to be communicating as quickly as possible. One thing that I'm advising a lot of clients to do right now, before your state gets in a situation where you may be ordered to shut down, is get current contact information for your employees. Make sure that you have current emails, text numbers, physical addresses for employees, because just think about how an order like this might come down in your state or local area, and how quickly you might have to let employees know that they're not coming in for a shift or they need to go home. It could be very quickly. So, take this time now, if you're not already under a shutdown order, to get that contact information from your employees. Go ahead and advance. There are some exceptions to WARN, and typically our clients are not able to take advantage of these exceptions very often. But in this situation, probably a lot of employers are going to be able to take advantage of these exceptions. The exceptions are if there's a faltering company that wasn't something that they could predict in advance, if there's an unforeseeable business circumstance, or there's a natural disaster. So in terms of the unforeseeable business circumstance exception, there might be a lot of situations now where employers are going to be able to say that the WARN Act does not apply because they couldn't give 60 days notice because the business circumstances that they're finding themselves in were not something that they could reasonably foresee. If it's something you could reasonably foresee, if you already knew before COVID-19 pandemic even was announced that your business was going to be shutting down or partly closing down or a mass layoff, then you're not going to be able to take advantage of that. But if you didn't know and COVID-19 is really causing this, it's unforeseeable, then this exception is probably going to apply. It applies when there's a sudden, dramatic, unexpected action outside of your control. You can see that many employers are experiencing just that right now. Next slide. Even though we all sort of, I guess, understand that we're all experiencing a lot of business losses right now, you would still have to be able to show the particular circumstances that are affecting your company. So I would suggest that you document, if you have a layoff or a closing, that you document why that's happening, the particulars of it. If you're sued later, you would want to be able to show that either you're not having customers anymore, a major contract was shut off, maybe your supply line was completely stopped, you're unable to make your product. You're just going to want to document that. If you're concerned about whether you qualify or the documentation, of course, you can consult with counsel about that. Next slide. Same thing with the unforeseeable business circumstances exception and a layoff. It could be that you lay off some employees, layoff meaning, they're not terminated, but they're just sent home. And you think it's only going to be 2 weeks, 3 weeks. A little while ago, we probably only thought this was going to be a few weeks. And I think we all realize this is going to be much longer, but we don't know how long. So if you start with, a shorter than 6 month layoff, but it ends up being more than 6 months because of unforeseeable circumstances, it could be that exception applies as well. And we certainly may be in that circumstance. Okay. The final exception I want to talk about is the natural disaster exception. I've never in my career had to talk about this. The definition under the federal law is floods, earthquakes, droughts, storms, tidal waves, tsunamis, and similar effects of nature. Even though we did have an earthquake here in Utah a couple days ago, that's not what's going on with COVID-19, but I think there's a very good argument that this is a similar effect of nature that's affecting lots of employers, and that this, would potentially qualify if the business exception didn't qualify for some reason. So there's really two good exceptions that may qualify your company to get out of the 60-day notice period during this time. Next slide, please. Now, one really important factor to remember is even if WARN doesn't apply, there might be other laws that apply to you. Maybe you're not big enough for WARN, maybe you're not going to lay off enough people or terminate enough people. Maybe one of the exceptions doesn't apply, but you have to look at your particular state and see if there are additional requirements. I've listed here some of the major states that have additional laws. We call them mini WARN statutes sometimes. California, Connecticut, DC, Georgia, Hawaii, Tennessee, Wisconsin. There's a number of them. And all the requirements are a little bit different. So if you're in one of those states, you definitely want to check and see if there's something else that applies to you. Something else that I would in normal times not mention, but now I definitely want to mention is even if your state is not on this list, this changes day by day. States are passing all kinds of legislation now to deal with these very unusual times. So if you're planning some kind of, terminations or layoffs, you've got to check to see if there have been any new laws or new requirements passed that might apply that's different than WARN or different than what we've dealt with before. And then finally, even if WARN doesn't apply and no other, state statute applies, there are other issues you have to think about if you're going to do any sort of layoff or termination, even in these times. If you're going to do that, you have to think about, is there, if I have to let 5, 10, 15 people go, I need to make sure that that's not discriminatory. I can't use this as an opportunity, for example, to just get rid of older workers or just get rid of workers who have had disability leave issues. It has to be non-discriminatory. And the best way to do that is to really make sure you have a good process that you document. I always recommend that clients use objective criteria for how they're going to decide who's going to be laid off, that they put a committee together that is, if possible, a diverse committee, and that they make the decisions. So you don't just have one person. If you have one person making the choice, then there's a lot better chance that someone could say, well, that person had a discriminatory intent. They wanted to get rid of women, or they wanted to get rid of this class of people. So you really want to have a good process and document that process in case there's a lawsuit down the line. And once you've selected the employees that are going to be terminated or laid off, you really need to look at that list and see, is it having a discriminatory impact? Are there more older people on that list? Or are there more women? Is that really fair, or is there something going on there that we need to figure out? And this is a situation where you might want to work with your outside or in-house counsel to really kind of analyze that process and that list. And also that helps you do it in a way that's attorney-client privileged. If you involve your counsel, you can have them analyze that data with you in a way that, there's more chance that it'll be privileged and not something that you'll have to reveal during a lawsuit. Next slide. Another thing you want to be concerned about when you're letting people go, always you want to be concerned about, but also during these times, is if someone in the past has made a complaint about harassment or discrimination, if they've made an OSHA complaint, if they've filed for workers' comp, if they've had FMLA leave, ADA issues, other health issues. Those are all situations that, we would call that a riskier termination or a riskier layoff, and you want to be a little more careful, make sure you really have all your ducks in a row in terms of choosing that person to be part of the layoff group. Okay, next slide. One final thing, if you're going to be letting people go, you want to look at their own individual employment agreements to see if they have any sort of guaranteed term of employment, if they're, you've promised that they'd only be let go if there's cause, if they're entitled to any severance under their agreement. Obviously, if you're part of a collective bargaining agreement at your company, you will need to look at that. You may have to negotiate with the union about what the terms of the layoff or terminations are going to be. And if you are going to provide severance to employees, you want to have a severance release agreement where they release their claims in exchange for that severance. And you want to make sure that that release agreement is compliant and that a lawyer has looked that over. Once you have decided that people are going to be let go, you want to make sure you're paying them any severance you're required to, that you're giving them any accrued paid time off that you're required to pay off. You need to look at your own policies and see if you have promised to pay people that, and also if your state law requires that you pay people time off if they're let go. Some states, for example, like California, require that you do that. There's also usually every state has some kind of law about how quickly you have to pay someone if you let them go. Sometimes it's 24 hours, sometimes it's 48 hours. You just are going to have to check your local state and see what the requirements are. You also, of course, if you're subject to COBRA or a state mini COBRA, make sure you're complying with those obligations and providing notice. Okay. I guess just the last thing is, as we're all dealing with this very difficult time, the companies that are going to do the best are the ones who treat their employees the best when we come out of this on the other end. And that means even if you have to let people go, being as kind and generous as you can. If you can, provide them contact information for unemployment and other assistance. If you can provide counseling, see if your health insurance has an employee assistance program that can help people out at this time. If you can have information meetings, if people are being let go, of course you would have to have those virtual. You wouldn't want to have live meetings, but as much as possible, really help employees out. Everyone's struggling right now, and that's all I have on that topic.
Okay, Christina, thank you very much. And a huge thanks to all of our presenters, Sean Monson, Susan Motschiedler, Ross Keogh, and Christina Jepson. Mark, I know we've had a number of questions that have come in throughout the course of today's discussion. And I know we're bumping up against time, but perhaps you could share perhaps some common themes or some common questions that have come in before we wrap up today. And Mark, your microphone is on mute if you're trying to speak.
Well, there you go. Thank you, Jason. I appreciate that. And because of the time, I'm going to try to breeze quickly through a number of these questions, and then a few I may refer out to some of the other panelists. I assume everyone can see the chat. It appears to be interactive. We've replied to a couple of the questions. The couple I thought would be quicker to just refer to quickly. The question was asked to go into more detail about the potential exception for first responders. As I understand it, under both leave provisions, the family leave provision and the paid sick leave provision, give authority to the Secretary of Labor to, in the anticipated upcoming regulations, to also exempt certain healthcare providers or emergency responders, neither of which are specifically defined in the statute, first of all. So that may be one of the first things that happens. But at least as to the paid sick leave portion, I believe the statute also allows a public health care provider or an emergency responder to just self-elect to not comply or not provide the benefits. It'd be a more accurate way to say it. I don't know if that is also the case with the FMLA, the COVID-19 leave. Sean, do you have a recollection or view on that?
Yes, I do. And the one thing that I would say about that exception, the healthcare provider and the emergency responder exception, is at least under the FMLA leave, the COVID-19 leave portion of it, there are definitions for what a healthcare provider, what that means. And essentially, it's part of the statute that's designed for, you have regular FMLA leave, you're going and asking healthcare providers to certify that you're entitled to leave. And so those would be, at least on the healthcare provider end, that's what I think, absent further regulation or guidance from the Department of Labor, I think that's who the statute is referring to could be exempt. An employer of people who can write certifications for folks who need leave under the Family Medical Leave Act, under the regular leave. For example, if you need to take leave because you have an eye condition or because you have another health condition, you have to go to a doctor, and the doctor certifies that you're entitled to leave or that you need leave for that condition. Those are the individuals that, at least, again, absent further guidance from the Department of Labor, are going to be exempt from the statute or potentially exempt from the statute. With regard to first care, with regard to first providers, those are not emergency providers. Those are not, or emergency responders. Excuse me. There's no real guidance existing under the Family Medical Leave Act for those folks. So that will need to be a subject for the regulation.
Okay, I'm going to answer a couple more of these questions. Go out on a limb on my own with the rest of you to back me up or correct me as the need be for just time constraints. Actually going up from the bottom, will we get a copy of the slideshow? I'm going to ask that to Jason, but I believe the answer is yes, that we'll have a mechanism for providing copies of the slideshow and likely also audio if you want a copy of the actual recording. Is that correct, Jason?
Yes, Mark, we will send out at the conclusion of today's call both the slide deck along with a link to view the recording. That'll likely come out at some point this evening. And just so you all know, if you have colleagues or others within your organization that would like to participate in this in a live environment, we are repeating this presentation on Friday, Friday, March 27th at 9:30 a.m. And I can include those details as well.
Okay, and thank you. And going to the next one up from the bottom, does the WARN Act apply to public employers? I will let Christina correct me if I'm incorrect, but I believe the answer to that is no. Straightforward answer from a lawyer for once.
That's correct.
Let's see, then I think we hit already that this doesn't apply to employers with more than 500 employees, and there will be some clarifications, hopefully, about exactly how those employees are counted when you have multiple entities that have some relationships, as Sean talked about a little bit earlier. Sean or Susan, do either of these leave provisions apply to employees that have not been able to work due to closures of the business? I would think that would be no. What's your view on that?
So that is somewhat of an open question now. We think that from the Treasury regulations, and maybe Ross can also speak some to this, that came out, that it will be fairly broadly interpreted. So in terms of voluntary shutdowns of businesses to not spread coronavirus, no. Okay, I don't think that that would count as a federal, state, or local quarantine. But for mandatory shutdown orders for specific businesses, or potentially for shelter in place, where individuals, again, important, cannot telework, that it may apply. So,
I think the answer might be a little bit different with regard to the Family Medical Leave Act provisions, because under the Family Medical Leave Act, as I talked about earlier, I mean, an employee does not get additional rights just because they're on leave. The company experiences a shutdown, there is a furlough, there is a reduction in force, there is a layoff, and that employee would have been subject to those regardless of whether they would have been on leave, and those leave rights don't continue. Now, that's under the regular FMLA. We don't know whether there's going to be further guidance about whether that pretty well established doctrine is going to be is also going to apply to the COVID-19 leave rights. Certainly, that's the way it is now under the regular FMLA. Now, of course, the tricky issue becomes with that is if people are on leave and then you have a reduction in force and you include them in reduction in force, you are going to most certainly have a good probability of inviting a retaliation claim. So that's the thing that you always have to be thinking about and be careful about, that if someone has exercised rights or has requested leave rights, terminating them, even if you're terminating them because of reasons that are unrelated to their request for leave, you're likely going to be facing a retaliation claim. At least there's a good chance of it.
Thank you. Another question, the COVID-19 FMLA leave does not, the question is, does it apply essentially to, or is it limited to applying only to those who, employees who have to care for children because their schools are shut down or healthcare providers are out, not operating, or is it limited to those? And I think the answer to that is also no. It applies to individuals who themselves have been are unable to work because they themselves have the COVID virus, or they've been ordered to quarantine, self-quarantine, or they're experiencing symptoms and they're seeking treatment. Am I mixing things up there, Sean, or is that?
Yeah, that's the way the statute was originally drafted.
Okay.
They had the same, the FMLA leave and the sick leave had the same trigger points. When it finally was passed by the Senate, the only trigger point for the COVID-19 leave or the amendment to the Family Medical Leave Act was just for a person who has to care for a child because the child's school is closed or because their preschool provider or their daycare provider can no longer provide that service. That is the only trigger point now for the COVID-19 leave.
Okay.
It's
Good.
related to Family Medical Leave Act.
Good clarification. Thank you. And I do actually I received another question by email that I'd direct towards Ross that I think is an interesting one. Given that this is funded through the feds by tax credits, are the emergency paid leaves themselves subject to payroll tax?
They're not. So if you're making payments to sick leave or FMLA under this act, you're allowed to not. You don't have to make a Medicare or a Social Security withholding.
And then let's see, we've got one last question here. I'll direct this to Sean. If you've got two employees who are married and married to each other, in fact, they have a minor child, do they each get 12 weeks? Or is that split between the two parents?
That is an interesting question that I think we hopefully will see guidance from the Department of Labor in the future. I mean, my response to that, I mean, that's a really interesting question. And I don't, like I said, hopefully we'll get some guidance. I don't know if we will get guidance to that. I would imagine that that it would probably, if there's two employees who are married, that it would probably be 12 weeks because it would be based on just that one child. It wouldn't, I think it would be unusual if the employees were allowed to say, well, I get my 12 weeks with this child, and then the next employee said, well, I get an additional 12 weeks for this child, because if it's the same child or the same children within the same family. But that is just my gut instinct. There's nothing to base that on in terms of regulation or any guidance from the Department of Labor.
And I think it, again, on the gut level with no regulations or guidance, I think it might follow the paradigm that exists right now under the FMLA for people otherwise entitled to FMLA leave who are married and work for the same employer, would be my guess. And that, so it's not necessarily a full 12 weeks each, but we have yet to hear. And last question here is the company designates individuals as employees as full-time if they work 30 hours a week or more. And if you have an employee who averages 30-ish hours, do you have to pay them all 40 hours per week, or can you pay them the average of what they normally work? And I'm going to hazard a guess that would be the latter. And that is when I say guess and gut reaction, it's tied to the fact that they're defining full-time employees as being entitled to 80 hours of sick pay. And that is also tied to a 2-week time period or 10 working days. So I think they're kind of implicitly working off of a 40-hour per week definition of full-time. But again, who knows what might happen. Anyone disagree with that?
No, I think that's right. I mean, I think that the statutory scheme does appear to base the full-time on 40 hours. I could also see a possibility of the DOL offering a little bit of guidance on that about what is full and what is part-time, and if you have to fall under your regular classifications. And the federal government has commented a lot on this lately in relation to the ACA. So there are some other sort of statutory schemes out there that have some guidance already.
And I'm going to seek some guidance from Jason and the rest of you. I'm happy to continue to answer and let people drop off as they want, but some things should come to a close at some point. should I take this last question here, and or should we pick up at another time?
Mark, why don't we take one more question and then we will conclude the call. And thanks to all of you again for sticking with us.
Appreciate it too. And what I've got here, the last one, this is also a very interesting question. What about employees who have exhausted all or part of their FMLA leave as of April 2nd? I assume it would be the rare employee who will have exhausted all of it by April 2nd, but it's possible. Sean, do you want to take that, or does anyone want to take that?
I don't. The statute doesn't give them additional weeks of leave. All it does is just give them a new trigger point, and that is now, in addition to getting FMLA leave for their own serious health condition or a family member's serious health condition or birth or adoption of a child, this adds another layer to it, but it doesn't add an additional 12 weeks of leave. It essentially just adds another reason why you can take the leave. So if someone's exhausted by as of April 2nd, I don't think they're entitled to any more leave.
And if it's only a partial exhaustion, they'd be entitled to the remainder. I would presume, do you start the 10-day unpaid leave portion at that point for their remainder, or do you kick in and start paying them?
Yeah, I don't know. I think that would be something that hopefully we get from the regulations. Again, without regulations, my gut answer would be you probably start with the 10 days. But that, I think, is an interesting issue that hopefully we get guidance on.
Right. Hey, well, thank you very much. Appreciate all of your participation and response and corrections where appropriate. So thank you.
Mark, thank you very much. And again, a huge thanks to all of our presenters today, Sean Monson, Susan Motschiedler, Ross Keogh, Christina Jepson, and Mark Wagner. As noted previously, I will circulate an email later this evening that will include our slide deck from today. I will also include information about the presentation, this presentation that we will be doing this upcoming Friday, March 27th at 9:30 a.m. If you have colleagues that would like to participate on that, or in that rather, they'll be able to join that webinar. Additionally, I know there was likely a lot of questions that we probably didn't have time to get to today. Feel free to contact any one of our speakers today, and they would be more than happy to address questions that you have and that did not get answered. And in closing, I'd just like to thank all of you for joining us today. On behalf of Parsons, Behle, and Latimer, we wish you all, we wish all of you and your families and your colleagues all the very best during this difficult time, and we are here to assist. So thank you very much for joining us for today's call, and we'll look forward to speaking with you soon.
Thanks.
Thank you.